So another issue comes up. What if someone else hurts my dog? So not just veterinarians, obviously we've covered that because it comes up a lot, but other areas, other professions such as dog behaviorists, pet sitters, groomers, and trainers have all encountered situations where their actions have resulted in liability to an owner or guardian for the death or injury to a companion animal. And for an animal business, where a caring image is really tied to attracting and maintaining clients, traditional diminished value of animal arguments or arguments as pure property, while they are available under the law, they can cause significant business losses. Sorry. In an increasingly pet-friendly world, where professionals would say this, they've faced scrutiny, and they, in fact, may lose clientele. And this is even true beyond just private businesses, but government officials, including police and government employees, have faced similar scrutiny for negative attitudes towards animals. It's for this very reason that animal businesses, however, may seek to settle disputes, often at a higher than anticipated dollar amount, with confidentiality and sometimes a non-disparagement type clause, because with social media and numerous reviews available through websites, negative publicity from an animal injury or death can cause customers to leave. And if the accounts are true, the animal business has no repercussion or has no recourse against the owner for something such as defamation or false light. And I would want to caution attorneys on one other issue involving settlement and businesses. This had never come up until very recently in my own practice, but be very careful with the settlement language, because in some cases a defendant may ask you or may seek to restrict your practice going forward. They may say, well, I'll settle this case with you for X number of dollars, but I want you to agree, you attorney, not you client, but you attorney to agree to never take another case against my client. Be very careful with language like that, and you should check your ethics rules for your state, because in many states, and probably most, if not all, such a restriction on future practice is unethical and is a violation of the ethics rules. So be very careful when you're looking at these settlement agreements, because while you can certainly, your client can bind themselves to confidentiality, and in fact through you, or essentially through your client, you can be bound to the confidentiality of the terms of the settlement. But beyond that, and beyond any other restrictions that your client have placed on your client, really any restrictions that would be placed on the attorney may very well be unethical, so you do need to check those very closely with your ethics rules. And I only mention it because it only came up more recently in a case where it was a contested or an issue that was raised as to whether or not it was appropriate. So just be very, very careful in looking at your settlement agreements. So the question that came up from the viewing audience was, do vets have a legal or professional obligation to disclose malpractice as opposed to affirmatively concealing it? And I hope I understand this correctly, but I'm assuming this would be to to the person who may be suing to say, yes, that they made a mistake. And I think I can answer that, hopefully, in a couple ways. If it is to the person who has a case against them, their obligation is to disclose exactly what happened. So in most situations, the vet will have to give the records over to the client. So if I bring Tuxie in for vet care, something happens to Tuxie, I come into the vet's office the next day and ask for copies of the records. They have to give that to me. Now, if they have to, whether or not they have to tell me it was malpractice or not, I don't think they do. I think that's up to me to prove. But if they, as a professional obligation to their own insurance company, if they have to reveal a possible malpractice, I believe that's true, like for every profession that would seek, if you're seeking coverage for it, yes. But as far as like affirmatively concealing it, if they were to affirmatively conceal, like to me, the client who's coming in for those records, then that is a professional obligation I believe that they could be in trouble for, not just in your civil case where you would sue them for fraud, but also in their disciplinary case where they would very likely not be allowed to do that, because that would be affirmatively misrepresenting one of their services or what they had done. So I hope that answers the question. I'm not sure if it does entirely, but each state differs in what their laws are for professional malpractice or for veterinary malpractice. So you should check those particular statutes with respect to what they would be required to report to a particular disciplinary body. With respect to their own insurance companies, that would probably depend on whatever company they have and what they're required to disclose. But with respect to a client, if I came in and my animal was harmed at their facility, I would expect to get all of the records with nothing concealed whatsoever. But all of that said, if you have, if a veterinarian has been sued multiple times, and in every situation there's a confidentiality clause as to the settlement, then you're probably not going to hear a lot about it. So because every situation, every contract, or I should say every client would be different, and there may be confidentiality, the new clients may not know about what happened in the previous cases unless they actually looked this stuff up in publicly searchable filings or cases. So they may not know what the terms of settlements are or something like that unless they took an active role. But so far as I know, vets, if they have been in trouble for malpractice, unless they actually receive a censure or reprimand from the disciplinary body, any investigations into that we're not going to know about. But I don't know that they have a duty to disclose to every client coming into their facility that they have been in trouble for something in the past. But again, that really will depend on the state laws, and it'll depend on what particularly is in those statutes for each state. So if that didn't answer it, please send in another question, because this is a live broadcast. So you should feel free to ask any questions, and I'll do my absolute best to answer them. And if I don't get them answered today, I will follow up through email. So please do ask away. But with respect to issues involving the other professions and liability, know that they come up, in boarding, grooming, training, dangerous products. I'm sure we all heard about the animal pet food cases and class action settlements. Of note, in the class action settlement regarding the pet food cases, they did not actually allow for enhanced damages, non-economic, because that was a multi-state case. So there were many states involved, depending on, if it had been brought differently in a different state, perhaps, or just in Illinois or just in California or one of the states that did allow some non-economic damages, that could have been a different result. But also airline mistakes happen. But I should note a caveat for the airlines. Those are typically governed, or they can be governed under the Montreal Convention. So when you get an airline ticket, be sure to flip it over and read, because there have been mishaps that have arisen when animals have been kept in cargo. It's an area usually for larger animals that may be shipped. People sometimes will put their dogs in crates and ship them. But in cargo, it's not as well regulated. The temperature is not regulated. Animals have frozen. Animals have been jarred around and killed during these flights. There have been laws that have come up that try to provide better remedies and better reporting for airlines, but just know that may be even more restricted than some other areas. So here's another question that came in. It says, since emotional distress non-economic damages is very rare in vet malpractice, can you give us an example of specific amounts that have been, I think that's awarded? Well, unfortunately, I cannot, just because most of the cases we've had have in fact been confidential as far as the settlement terms. I can tell you that in the cases involving negligence, ones that we've settled amounts for around $19,000, but again, they can go any amount. The reason they're, as far as emotional and non-economic damages, I wouldn't say very rare. In fact, people ask for them all the time in vet malpractice cases. It's dependent upon your state as to what you're going to be allowed as far as whether it's going to be actual value or whether it's going to be lesser value. But the reason that can vary quite a bit as well is that if your animal is not necessarily just your companion animal, and even in a state without the kind of actual value damages, your animal may be a therapy animal. Your animal may be a breeder dog. Your animal may be a horse that you're breeding for racehorse purposes. So these values can range very greatly, $1,000 to hundreds of thousands. You just don't know. But as far as veterinary malpractice, again, this is going to depend, on the state, and it also depends on what other actions are wrapped into the veterinarian's actions in that case, whether there are other tort damages involved. But yeah, it's very difficult, and a lot of these cases most of them settle with confidentiality. But if you have an actual value standard, you certainly can ask for greater amounts. And in a settlement, if they're asking, if someone is asking for confidentiality, then we typically will ask for additional money to cover the confidentiality, because a lot of the animal owners feel a duty to report what happened and a duty to tell others because they don't want that to happen to other people. And the vast majority of people who come in on veterinary malpractice actions, at least in my office, are not concerned. They don't want a big windfall. What they want is to be heard, and they want to be sure that this never happens again. So, unfortunately, I don't have a good answer. I will follow up because I do know of one case in California that came out recently with a much higher award. I just don't know exactly what that is, so I don't want to give you bad information right now. So I will follow up with that question. But yeah, traditionally the values have been very low. But again, the goal, or I guess it's not the goal, but the trends have been changing. The recognition has been that animals, certainly companion animals, are worth more. But it really will depend on your state as to how much more. And again, note that, with the negligence-based claims, which the question had asked, those cases usually bring up actual value or negligence standards, and know that there is liability insurance typically in place for all of the businesses involved. And that's something that liability insurance is yet another reason that the damages have been kept lower, because most of the insurance providers obviously would like to keep the damages lower. And it is a concern for these businesses, because I've represented businesses as well, that with enhanced damages, that there are going to be higher insurance costs, higher costs all around. So there is an argument for both sides of this issue. Also, businesses typically will have waivers and disclosures, but much like the waivers and disclosures covered under the vet malpractice segment, there should be some care taken in crafting these, because they may be against public policy and they may not be enforceable. Thanks. For the people in California, California also has a standard similar to Illinois. So I apologize for not covering that entirely, but I appreciate the follow-up. Also note that another area that comes up in animal cases, probably more so for boarding and grooming and issues outside of the veterinary malpractice. And I say that because in some situations, veterinary malpractice may be exempt from certain consumer fraud statutes because it may be considered a healing art. This is an area that is in flux, and it's somewhat debated, although there hasn't been a definitive answer, I think, from any of the courts, at least in my own state, and I'm not even sure so much in the other states, as to whether veterinary actions or the practice of veterinary medicine would fall under the healing arts, or whether it would fall under a service akin to boarding and grooming. The reason that's important is because most consumer statutes or consumer fraud laws will cover the services, such as boarding and grooming, but would not cover or would not be applicable under healing arts, which you may see from an acupuncturist or a medical doctor or psychologist or something else. Some even professions would not be covered under the consumer fraud statutes. But in the situations of boarding and grooming, where a service is not as advertised, consumer fraud does in fact come up. And it is important because many, or if not, most consumer fraud statutes do allow attorney's fees. So it is an incentive to bring cases out of protection for public policies and for the public's well-being. Also, it's not on the list here, but I do bring it up because it's become an area of increasing, I guess, it's under scrutiny a little bit more. is private and public animal shelters, because they've recently gained more attention as part of the no-kill movement in efforts to decrease euthanasia rates. As we talked about very early, is the high euthanasia rates at shelters for animals, and unfortunately the millions that are killed every year. But this kind of, I guess, the euthanasia issue can be difficult for public shelters because these are funded by taxpayer money and may be expected to have an open door policy, accepting all animals essentially, although space is limited. Private shelters can have more flexibility with the type, timing, and the stipulations that are placed upon animals that are accepted, but they can suffer from inadequate funding. Both types of shelters handle relinquishments, or just the fancier name for owner give-ups, and strays, or those animals of unknown origin. The states do vary in their hold times, and this you may find in state laws as to what amount of time a particular shelter is required to hold an animal before disposing, euthanizing, or dispatching, giving to another shelter. Or, unfortunately, in some situations, pound seizure does still occur, where animals that are submitted to shelter, depending on the laws in states and local governments, can be transferred for biomedical or other types of research. So that's something, I guess, those potentials that could happen to an animal are the reasons that a lot of, another trend is to require shelters to report their statistics. And that includes private and public shelters for accurate statistics. And these may or may not be available currently pursuant to the Freedom of Information Act, because each state differs in what they require of the particular animals that are put into those, or require of the reporting of those shelters. Lawsuits have in fact been brought against shelters for misrepresenting the fate of animals brought into their facility. So it's important, if you have shelter clients, to let the shelters know that they can't simply tell someone who's bringing their animal in, no problem, we're going to find Fluffy a home. Because if in fact they are a kill shelter, they can't make that guarantee. They are then inducing fraudulently someone to sign over their animal to the shelter. And even though they're giving a benefit to that person by taking in the animal, they are misrepresenting what may happen to that animal. So it is important for shelters too, because there have been lawsuits. They have not. I know the ones that I know of were not tried to completion, but they were in fact brought as far as what was misrepresented by the shelter. Similarly, pet shops and the animals that are sold there can also face liability for failing to properly disclose the known sicknesses and behavioral issues of animals that are there. So that is yet another area. We'll cover it a little bit later in some of the trends, but all of these, all of pet shops, adoption agencies, any of these particular businesses, really to protect themselves, should reveal everything they know about the particular animals that are being sold. It is, buyer beware, but there are certain requirements. It will make it much easier for that business to avoid future liability if they disclose everything. Similar for the shelters, if they disclose all the temperament testing performed on the animal, all of what is known, all of the health history before adopting that animal out, they can drastically decrease their liability for the future. And, especially for shelters, making sure that they do not represent what could be the fate of that animal if they cannot make those guarantees.